Hi, I'm Karin Weston, a paralegal at the law offices of Jacob Aronauer.
Hi, I'm Sean Ricketts. I'm also a paralegal at the law offices of Jacob Aronauer.
Yeah, and we have some more mailbag questions this week. So, Sean, would you like to read the first one?
Of course. Derek from Brooklyn asks, I was a server in a fine dining restaurant for 5 years, but was recently fired when the restaurant came under new management. I'm African American and I have long dreads. When the new manager came in, she rewrote the employee handbook and changed the restaurant grooming policy so that it specifically prohibited dreadlocks. As part of this change, the manager told me that I needed to cut mine off. When I told her I was not willing to, she fired me. Was this legal? Is it legal to discriminate based on hair?
Yes, so short answer, no, it's not legal to discriminate based on hair. The New York City Commission of Human Rights recently made that more explicit in some new guidelines in February 2019. Basically saying that discrimination on the basis of hair is racial discrimination, falls under that under the New York City human rights law, and
Yeah, so they clarify that specifically in New York City, of course, it's illegal to discriminate based on race on the federal and the state level as well. But specifically in New York City, they clarify that they protect the rights of New Yorkers to maintain natural hair or hairstyles that are closely associated with their racial, ethnic, or cultural identities. For Black people, this includes the right to maintain natural hair, treated or untreated hairstyles such as locks, cornrows, twists, braids, bantu knots, fades, afros, and or the right to keep hair in an uncut or untrimmed state. And the guidelines go further to clarify that it doesn't matter what kind of establishment you work for. Even if you work for a restaurant or a construction company or some company that they might say that it's for reasons of safety or food safety, they're legally obligated to find a way to contain your hair for safety purposes that does not involve asking you to change or eliminate your hair. They have to figure something else out. So it absolutely is not legal to do what your manager did, and you could sue them.
Yeah, and if you did go the route of suing your former employer, so what would the damages be? Basically, those are connected to things like what the amount of money that you would have made during the time that you would have been working there if you hadn't been fired in the racial discriminatory way, and also how much you might make in the future or would have made in the future at that job, especially if it's a job that's kind of hard to get. So if this is a fine dining establishment, it's maybe hard to get like one of those more lucrative restaurant jobs. And you're also entitled to emotional distress damages. And then there are also punitive damages that can be involved as well to help prevent your employer from doing what they did to you to other people in the future.
Right, which can really add up. So the law is really on the side of employees here. They really, really want to punish employers for this type of discrimination, rightfully so.
Yeah. Great, so let's move on to our second question here. So Julie from Manhattan writes in, and she says, I work as a paralegal for a law firm in Manhattan. And despite the fact that we are only in phase 1 of reopening, my boss has decided to reopen our offices next week. While I understand that business has suffered with everyone having to work remotely, this move seems premature, especially considering that it is possible to do our work from home. Furthermore, while I am not in an at-risk group, I live with my grandmother and am worried about the possibility of infecting her if I get sick at work. Is my boss allowed to force me to go back to work before the stay-at-home order is lifted? What should I do if I don't want to lose my job?
So this is a great question, and one that unfortunately is likely to be asked many times in the coming months. So New York is currently in phase 1 of reopening. This is specifically New York City. Other parts of New York, you should look up what applies to your region. But in New York City, phase 2 will not start until at least July. And the Department of Labor gives very strict guidelines clarifying that if your business is not currently permitted to operate, if you're not currently in that phase, your employer cannot force you to go to work. And in order to be considered an acceptable workplace, they must take various health, safety, and health precautions, including providing you with a face covering, ensuring that social distancing is being followed, making hand washing and sanitizing stations available, and making sure that cleaning and disinfecting is occurring frequently. They also clarify explicitly that your employer has the responsibility to make operational adjustments like teleworking to the maximum extent possible and staggering shifts. So your employer, if teleworking is possible, they are legally obligated to make that possible for you. They cannot force you to return to work. They cannot threaten or retaliate against you for complaining that the business should not be operating or has failed to take adequate safety and health measures. So it's not legal for them to fire you if you refuse under these circumstances. The Department of Labor does provide a link to a page where if your employer has done any of these things that were listed that we just talked about that are not lawful, you can file a complaint with them, and we'll include a link to that. They also specifically say that you can file a complaint if your employer is forcing you to work when you're sick, or if you have particular concerns because you are a family member or part of a vulnerable population. So this questioner basically has many, many reasons under the law why she cannot be forced to be returning to work next week.
Yeah. And I'd also just mention on the Department of Labor website too, there's a section where you can look up, like if you're not sure whether your business is allowed to open up at this point, you can look up that information.
Which is very helpful. We know that it's very confusing. We are also New Yorkers, and so we are also trying to keep track of what is open and what is going to be reopening, so we really understand this concern and want to we're all in it together.
Yep.
So our final question is from Nikki B, who worked as a bartender for 8 years and they were not paid time and a half for all hours worked. First, can they sue for all 8 years, or can they sue for only a limited time period? Second, they were paid off the books, which they know is against the law, but because they're an illegal immigrant and did not have their tax papers, they had no choice. Because they worked off the books, I did not file taxes the past 8 years. I'm afraid to sue because I'm afraid if I sue, the court may want to see my tax returns. Can you let me know what I should do? Thank you.
Yeah, so we've kind of got a two-part question here. One is about the time period that Nikki was working, and then one is about the taxes and immigration status. So in terms of being able to sue, so Nikki was working there 8 years. In New York State, you can go back and collect damages for 6 years for unpaid wages. And that's more generous than the federal law, which is just going back 3 years. In terms of the second part of the question, that's a bit more complicated. To begin with, I just want to mention that we always recommend that people follow the law and pay their taxes.
And that goes for both employees and employers.
Yeah, everybody. But in these FLSA cases, the immigration status of the plaintiff suing and their tax history it's what we call not discoverable. It means that the other side can't ask for that information, and so that it doesn't come up in these suits.
Right, and it's important to also clarify that it's not a law that it's not discoverable. It's based upon precedent. So what it's based upon is a 2015 ruling that made this very clear. They stated that federal courts have made clear that protections of the FLSA, the federal labor law, are available to citizens and undocumented workers alike. But because this is not signed in the legislature, this could change. But this is currently the situation. It does protect non-citizens from workplace violations.
Yeah, exactly.
Well, it's great for another week of mailbag questions. We look forward to talking about employment law issues with you again soon, and we hope you have a great weekend.
Great. Bye.